Our next case is State versus Hutchins. Each party will have 15 minutes to present their argument. Counsel, how long would you like to reserve for rebuttal?
2 minutes.
3?
2.
2, very good. I will make note of that. You see the clock up there on your left. Please look at the top clock if you will. As you, like me, may have a hard time reading and looking at the clock at the same time, but glasses, I will let you know we're about 3 minutes left in your time. You have about a minute left in your actual time. I'll give you a warning if you get to that.
Thank you, Judge.
And also, of course, you'll be leaving at middle clock and we'll give you a minute as well, counsel. The arguments are being recorded. When you come up to the podium, please introduce yourself. Please stay behind the podium so we can see you visually on the recording, and please speak loud so we can hear you on the recording. You should not use the name of any child, minor, or victim in this case. Please use initials or some designation like victim or minor or child. We've read your brief and are ready to proceed with it.
Thank you, Judge. My name is Attorney Elroy Jones, and I'm happy to be back. This case is, well, they're all fascinating, but it's an appellate case only, where you have just a compilation, just a flood of basically things that can be corrected during the course of the trial, which are not corrected, and which result in, frankly, not having the ability of a defendant to have justice. Notes. Ineffective assistance of counsel. There are certain things which I constantly read in Court of Appeals. Well, that was some sort of trial tactic. Giving up a motion to suppress, it's not a trial tactic. It's just ineffective. You give up a chance of getting rid of evidence. And then just the notes again before I came in, sort of run through them. They're in the brief and they're in the record. There's prosecution misconduct in setting up this roofie scenario. You know, a week before the prosecutor finds out from detective, oh yeah, by the way, she had a cinnamon drink. And geez, how well will this segue into Dr. Savitsky's testimony?
Did the counsel for the appellant here object? My understanding, the trial counsel did object to the cinnamon flavored drink coming into evidence.
Absolutely. That part's good.
So how is that ineffective assistance of counsel?
Not that part.
Okay.
The bad part comes when the judge doesn't grant a mistrial over it, or at least give a short continuance.
Counsel, perhaps this would, I appreciate your approach through these errors, and if you could maybe help by specifying what the error specifically is and sort of what your argument is about that error and the standard of review that the court should be applying, that would greatly aid the court.
Well, I think that there is plain error. If I could, again, specifically, the defense had objected on a number of occasions, I think even before trial began, to Dr. Savitsky testifying because, number one, she was using a generic report that she had used years before. There was nothing in the way of any real scientific examination that she had done. There was a lot of hypothesizing, and all of a sudden, a case that's supposed to be an alcohol case, which would be, I think, a little bit easier to manage. All of a sudden, we now have two things that are going on. And the defense is surprised about that. There isn't any two ways about it. Then the ineffective part comes on the curative instruction that the defense tries to get, which basically says, well, we'll disregard a little bit of therapy and so on, as opposed to not agreeing to that. It was just basically kind of forget about the therapy part and not continuing to demand absolutely that there is a mistrial, that there was no potential curative instruction. All of a sudden, that case, when that evidence comes in from the cinnamon drink and then followed up by the corroboration by Dr. Savitsky, that case was over. That was a done case. And you look at the attorneys, I have absolutely no idea what in the world they were doing and not calling her to the stand. There was a great, I mean, the trial tactics are completely deficient. You call that client to the stand and have her talk about Mr. Gerald and what the influence is on her and how, because again, that room is torn up. It isn't my client who tears that room apart. That's this, I'm going to call it crazed, Mr. Gerald, ripping up doors, tearing things off hinges, you know, and he's the one who's performing, you know, the sex acts. You know, my lady is at best, you know, according to the states and what the judge fined, she's an accomplice. Yeah, standard review, this, I don't know quite how to phrase the standard review except it's plain error. And it certainly is just as stated, it's just a compilation of errors. Errors that could have been corrected. A judge should not, during a trial, call a complaining witness a victim. You've already got them convicted. The judge has said, we have a victim. No good. That's not justice. The state has, like any other witness, a complaining witness. They do not have a victim until there is evidence beyond a reasonable doubt, and a judicial officer indicating that such exists before such evidence has been decided upon by the finder of fact, that there is in fact a victim. This adds up. I mean, there's just no way you get a fair trial under this situation. Again, on the Rufinol, there's no lab reports, there's nothing in the evidence that enables it. You know, I mean, again, the witness says, yeah, I don't remember anything after I got in the car. It's in the record. Page numbers are over there in the transcript, it's there for you. I don't remember anything, that all of a sudden later on in testimony, what she remembers that there's all kinds of things going on in the room. What you get doesn't match up well with the roofie. And if in fact the defense had an opportunity to know that this was the way that this road was going to be followed, then they need to be demanding their own experts to combat the doctor. Again, I think they justifiably rely that Dr. Savitsky's testimony should not have been admitted to begin with. But with that being, you better get an expert to go against this. So there's no rhyme nor reason to trial tactics that this gentleman had involved in this case. Prosecution misconduct. Again, you can tell basically from even the closing statement. It's like it just is. It's a setup all the way around. Once that cinnamon drink comes floating through here, all of a sudden, that case was over. And again, then the prosecution in closing, well, you know, you can have drunk, and you can have drug rapes can happen. Not uncommon. You know, I get emotional over these things because, again, it just seems like I think that the cases that we have cited are in fact sufficient. There is sufficient misconduct here on the part of the judicial officer, which is, I don't say it's purposeful, but again, that's the reason why we have Court of Appeals, because the only reason you really get anything out of the Court of Appeals is when they review what happened by the judicial officer. That's where most of the stuff comes from. And again, I believe that the evidence is replete. Again, thinking about the defense attorneys, they've got an obstruction of justice because she didn't say where the address was. They've got a theft because they see some dollars on a wallet moving back and forth on the videos. I get that. What trial tactic with such obvious things is there to proceed with the trial where you've declared not guilty on all items involved in the case, all counts of the indictment, including, the misdemeanor counts. That makes no sense. You diffuse that, the only trial tactic on that is admit, guilty, because then you've got a jury considering things which are completely not refutable. And again, you're putting your client in a bad position. Again, there's no particular trial tactic that these fellows are advancing that frankly makes any sense when you're defending a criminal case of this nature. The failure to file, again, as mentioned in the statement of facts, there's no surprise to the prosecution what's going on here. And again, the record is replete that there's, again, discussion about the motion to suppress. And again, it makes absolutely no sense for any attorney not to take a look at that. Now sometimes you wind up where the state says, well, if you file that, we're not going to give you any kind of, other deal or a reduced charge. I have no idea what happened with that, whether or not that was a reason why they didn't file. But again, it certainly is a huge tactic that makes no sense to give up. Again, it is just like dominoes. Boom, 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 boom. When you add up all of these errors that could have been corrected, when you add up if in fact they had prior notice of the roofie coming down the road, besides apparently some generalized testimony, which what in the world is there generalized scientific testimony? It needs to be particularized to the facts that you've got, and giving the defense then the time to diffuse those facts or provide an alternate situation of what they may or may not mean. So again, the defense on this was hamstrung by that, and at points of times the defense hamstrung themselves. Again, no evil intent has to be looked for here in error, with the exception, again, I find it concerning about the prosecution conduct in this case. Nobody wants to say that, but the facts here certainly lead to a really strong inference on that. Again, there was actually no reason to not disclose this the week before. Give these guys a chance in the defense to respond. There was no such thing done, and I understand it's an extraordinary thing to ask you to do. But if you're going to preserve justice for defendants who are presumed to be innocent, they should, one, have effective representation, not ineffective. Number two, there should be rulings by the judicial officer which comport with what is either admissible or not admissible evidence, or some admissible evidence comes floating in. You give a strong curative instruction. You are to disregard completely. It is not of any consideration whatsoever. It's like the instruction about a defendant. They don't have to testify.
About a minute left in your initial time.
Thank you, Judge.
May it please the court, Helen DiMartino on behalf of the state of Ohio, the appellee in this case. We are asking that this court affirm Ms. Hutchins' convictions and that this court find that there was not cumulative error in this case. With regard to the cumulative error, I would just initially point out that the assignment of error in the appellant's brief that sets forth the argument and the roadmap for what they are articulating here makes a passing reference really to this misconduct. It says, prosecutor committed misconduct with regard to the cinnamon water, but doesn't really flesh out that argument or set forth a standard, which made responding to the arguments a little bit of a challenge. I believe it's set forth in the index as well as on page 14, but in that long single-spaced paragraph, it just says, prosecution committing misconduct for knowingly failing to provide in discovery because he had been told by the police officer a week prior to the testimony. So didn't really put the state, I would say, on notice of exactly what the argument was. But to respond to that, when the argument was articulated that there was some surprise about the cinnamon flavored water, The attorneys for Ms. Hutchins as well as Mr. Gerald had a conversation with the court. The court allowed the state to respond. The state responded that the officer had been told by the victim that the water in the vehicle tasted like cinnamon. There was a break that was given. Ms. Hutchins' attorney notes that on page 7 of the brief, where there's a quote to the transcript without a page reference that talks about a 15-minute break that was given to discuss the fact that she was in therapy as well as the cinnamon water. When they returned, Ms. Hutchins' attorney agreed to a curative instruction. When the officer testified and when Ms. Hutchins testified about the cinnamon water, there was an ability to cross-examine her on that. So there is not a basis to say that there was any prejudice there. There is no evidence of prosecutorial misconduct other than this, just allegation here that something that was discoverable. We certainly gave the witness list. The defense knew that Dr. Saborski was going to testify. Part of what she was testifying to was what happens with drug-facilitated assaults, including alcohol as well as GHB. So all of those things are in the record.
Counsel, with the cinnamon water drink, though, that was not in the record, right? The officer testified that he did not put that in his report.
Right.
And had only thought about it later.
And had only thought about it later, and there was no indication that when the victim gave that information to the officer that was before she had engaged in therapy, which was part of the other arguments, is that she was recalling things while she was in therapy. So there was no evidence that it was an ambush. The prosecutor, it sounds like, knew about it a week before, even though we had already put them on notice that we were going to introduce evidence with regard to an expert on drug-facilitated assaults and how that also can include alcohol.
And that was subject to a motion in limine then, right?
Correct. So with regard to that, there's no ambush here. There's no evidence to support that. That's just an argument that's kind of casually being made in the brief without anything really to support that. And as I indicated, there was a continuous that was given, there was ability to cross-examine, and I guess more importantly, the expert did testify that she was not saying to a reasonable medical certainty that this individual had been the victim of a roofie or anything to that sort. And in closing argument, the prosecutor went through a discussion about why we had the expert come in and how, the full story is what can happen with things that are metabolized and how quickly they might come out of the system. So we would argue that there's no evidence of any type of prosecutorial misconduct. With regard to whether there was ineffective assistance for not filing a motion to suppress, when you look at the appellant's brief, the citation they make is to the victims, the co-defendant, Ms. Hutchins, saying, I think I should talk to a lawyer, not an unequivocal, I would like to talk to a lawyer, nor is there any indication of what, if anything, Ms. Hutchins then said that should be suppressed or anything that came in that was prejudicial. So they haven't met their burden of showing that was ineffective assistance of counsel. They haven't raised an ineffective assistance of counsel argument separate from this cumulative error assignment as well. So based on the evidence that's set forth in the brief with regard to the evidence that came in, which is the same evidence that we talked about earlier when we presented our argument with regard to the co-defendant, Mr. Gerald, there is overwhelming evidence that Ms. Hutchinson, Mr. Gerald, and the victim were together that evening. There's surveillance video footage from the Motel 8, from the Musketeers bar, from where they went after they had dinner at Johnny's, showing the victim clearly incapacitated. There's evidence from the victim with regard to how much alcohol she consumed and how it would not have been a sufficient amount to cause the memory loss that she had. It sounds like there's no dispute from Ms. Hutchins that the hotel room was in a disarray, that there was broken doors and evidence of a struggle, bra left on the floor, pieces of hair on the floor. The victim indicated that she had been touched by both Ms. Hutchins as well as Mr. Gerald and then didn't recall much else. There's the DNA evidence that placed Mr. Harrell's DNA on the victim, which would support the allegations of rape and sexual battery. Clearly, Ms. Hutchins was tried and convicted as an accomplice of Mr. Gerald. And based on that, the state would argue that there was sufficient evidence, there was not plain error as being articulated here, or any type of cumulative error that would require that Ms. Hutchinson's convictions be overturned. There are no questions. I would rest on my brief. Thank you, Your Honors.
Thank you.
Again, there are no surprises to the prosecution of this appeal. The issues presented at the court review are under the totality of the errors. That's the appeal. Attorney's failure to file suppression concerning statements made after indicating desire for an attorney. It doesn't matter whether that would be granted, I guess, or not. That's something yet to be determined. But it's certainly an issue that should be followed. Judge referring to DB as a victim during the trial as opposed to a witness. The trial court allowing Dr. Savitsky to testify, but the doctor had nothing to opine in the way of reasonable medical certainty considering this case, and use of a prior report that she had given years before by just simply changing names and dates. Again, the court should not have let Dr. Savitsky testify. The trial court not granting a prompt mistrial for the surprise cinnamon drink and therapy records, which a short continuance, something could have been done to at least give the defense attorneys an attempt to react. Believe me, criminal defense attorneys are, as you may like it or not, are at a disadvantage. We don't have professional witnesses. We got to go out and try and get them. We're putting on people who have testified 15 times in front of the jury. So we've got a mountain that we climb. That mistrial should have been granted on that cinnamon drink. And then the failure of the attorneys to get a curative instruction, not only on therapy, but about the cinnamon drink. Again, once that came in, and this became a roofie and not a drug case, and once they let, ridiculously allowed those other two criminal charges there completely, just, it was, I don't know, I don't think we needed a trial, almost, the way that this thing played out.
Thank you, Mr. Jones. And on behalf of the court, thank both of you for the presentation this morning. The court will take the matter into advisement and issue a decision in due course. The clerk of court will mail a copy of that decision to you upon release. Also be available on the High Supreme Court website. With that, I will say the court is now adjourned until